This conference will now be recorded.
I'm Stephanie Schneider, and I'd like to welcome everybody to today's webinar. It's Friday, October 22nd, 2021, and our topic today is called In Sickness and in Health, What to Do When Your Spouse is Diagnosed with an Illness. Now, we're going to be covering a lot of information today. We're not just going to be talking about some of the legal tools that are available, but we're also going to talk about some financial tools that are available as well. And I'm going to provide some tips of things to do before a person becomes ill or incapacitated, as well as what to do once the diagnosis is received if those steps were not previously taken. So I'd like to begin our discussion today with a little bit of background involving statistics on what is happening in our country when it comes to long-term care. And what does long-term care really mean? And we're going to explore what does Medicare cover and what doesn't it cover, because there's a lot of misunderstandings that people have. So we want to leave all of you with clear, accurate information today. So statistics are telling us that 70% of people who are over the age of 65 may need long-term care during their lifetime, and that 48% of individuals over age 65 are going to need paid long-term care, meaning that they are going to be fiscally responsible for the costs incurred. Now, while some of these statistics are focusing on an older age, that does not mean that younger people won't need long-term care. And we've seen in the last year and a half, as we have lived and survived through COVID-19, that that is a real-life example of how people of any age are being impacted. So I hope that this information will be considered by people of all age groups. Now, statistics also tell us that people who do need long-term care are going to need it for approximately a minimum of 2 years, maybe longer. And that 15% of people that are over age 65 will possibly need that long-term care services to be provided to them in a nursing home. And we're going to talk just in a minute about other places that long-term care services can be provided. We are seeing an increase in reporting of care that is needed for people diagnosed with cognitive impairment, such as dementia or Alzheimer's. And we want to be concerned, and part of today's webinar really is directed not just to the individual with the diagnosis, but also to the caregiver, because there's a very strong impact that illness and disease have on the person that is the primary caregiver for the patient. And that impact happens on many levels, on a physical level, on an emotional level, as well as on a financial level. So we want to make sure that the caregiver is taken care of as well. Now, you might be shocked to learn that only about 8% of the actual cost of long-term care services is paid for through private insurance. Now, that could include insurance that you have purchased. It could also include long-term care insurance. So what is long-term care? Well, when it's defined from a medical point of view, it could mean the highest level of care that a person needs, which is skilled nursing care. That means the care must be provided by an individual that is licensed. That would include a medical doctor. It would include a nurse, such as an RN or an LPN, and a certified nurse's aide. Now, skilled nursing care usually means that it's been necessitated by an illness or disease process that affects the individual's ability to perform at least 2 or more activities of daily living. Activities of daily living are things that we do every day that we might not even think about, we might take for granted, and that is our ability to feed ourselves, to go to the bathroom, to groom ourselves. That means our ability to take a shower or a bath, to wash our face, brush our teeth, comb our hair, hygiene. It includes the ability to transfer, maybe getting from a bed to a chair or a bed to a wheelchair and vice versa. So if a person is unable to perform a minimum of 2 activities of daily living independently or with some minimal assistance, that might indicate they need a skilled level of care. Another indication that a person might need a skilled level of care could also include that they are unable to properly self-administer prescriptive medications. That means that they may not be able to remember to take the medication, or that they may not take it correctly, meaning the proper dosage or the number of times a day the medication is to be administered as prescribed by the doctor. Another reason an individual may need skilled nursing care, but not always, is if there is cognitive impairment. Now, the reason I said not always is because sometimes people have a diagnosis of cognitive impairment, but physically their body is healthy. So they're able to perform activities of daily living without assistance or maybe with minimal cues, but it's the cognitive abilities to process, to use good judgment, to use reasoning skills, or to remember that is affected. So sometimes people need long-term care not at a skilled nursing level, but perhaps at a memory care center. Now, long-term care can also include care that is provided at home by a home health company, meaning they're going to provide a home health aide or a certified nurse's aide to perform certain services. And as I mentioned, it can include that a person has severe cognitive impairment, or the illness has continued for a prolonged period of time, or the disability has been present for a prolonged period of time. Now, many people think that the healthcare system called Medicare covers long-term care services. And this is partially due to the fact that there was either misinformation or lack of accurate information over the years. And so people think that when they turn age 65, they will automatically be covered for anything they need through Medicare. But that is not correct. When Medicare was designed as a system in the late 50s, first of all, people had a much lower life expectancy than they do today. So because people had a lower life expectancy, the focus and the goal of the Medicare system was intended to pay for short-term illnesses and short-term health care costs. It was not designed for the reality we have today, which is that people have illnesses such as Parkinson's disease, which can last for many years and be debilitating as the disease progresses, or Lou Gehrig's disease as another example, or Alzheimer's. So Medicare is not going to cover the long-term care costs that we are discussing in today's webinar. If you went into a hospital, whether it was planned or not planned, and you had some sort of a surgery or a treatment, there will be coverage for the hospital stay under Medicare. And if the doctor at the hospital refers you to a rehabilitation center for physical therapy, occupational therapy, or speech therapy before you can go home. If you've had a qualifying 3-day hospital stay, and qualifying means that you didn't just sit in the emergency room, it means you actually were admitted into the hospital, then Medicare will cover 100% of the cost of the first 20 days in the rehabilitation center. There is the possibility that Medicare will continue to cover 80% of the cost from days 21 through day 100. But at day 100, Medicare will stop paying, and that applies across the board to everyone, despite what the diagnosis is or the condition of the patient. Now, whether Medicare continues to pay 80% starting at day 21 has to do with how the patient is responding to the treatment and or progressing. It is not a requirement that the patient necessarily progress. So if you hear that or you're told that when you or somebody you know are in a rehabilitation center, you need to tell the administration that is not a basis for stopping therapy. The patient has the right to demand that the facility not make that call, but actually submit their billing to Medicare to make that determination. So progress is not the sole requirement of whether Medicare will pay. If the patient has been made stable because of the therapies being provided, and they would go backward in time with their progress if the therapies stop, that is another grounds for Medicare deciding that they will pay 80% for days 21 through day 100. So as you can see, since Medicare is not intended to be a payor for long-term care costs, we have to take on that responsibility. We have to be educated consumers, and we need to plan ahead. So let's start our discussion on what we all can do from a legal point of view to plan ahead. And we're going to talk about what to do before as well as after receiving a diagnosis. So I like to consider this part of our discussion as having two parts. The first part is what I call creating an incapacity plan. And the second part is what I call having an estate plan. And they're both equally important. One does not replace the other, but they actually work in tandem with one another. Now, the incapacity plan consists of 3 types of documents that work for the sole purpose of creating a management system while we're alive, but if we become either temporarily or permanently incapacitated. And there's 2 sides to the incapacity plan. There's the side that helps us address who's going to make financial decisions if we become ill, and there's the side of who's going to make my medical decisions if I'm incapacitated. And we're going to address both sides today. So the durable power of attorney is the legal tool we use to create a management system if you become incapacitated and cannot make financial decisions. So think about what are the types of financial decisions you either make on a daily, a weekly, or a monthly basis. They may include that you go through your bills when they arrive, either paper bills or bills that you have set up to come electronically by email that you need to pay. It may also include that you need to look at your monthly financial statements, reconcile them, and or if you have investment statements, you need to look at them and make some decisions. Am I keeping the investments the same, or Do I need to call up my advisor and talk about changing some of the investments? Or what about when it comes time for you to meet with your accountant each year and go over tax information so that the accountant can prepare your tax return? Well, if we're incapacitated, our ability to do those things may be limited or compromised, and we certainly don't want that side of our lives to just stop and be in limbo. So the durable power of attorney is a legal tool that's used for you to give permission to people that you trust, that you have confidence in, are going to make the decisions you would make if you were able to. Now, the difference between having a durable power of attorney versus adding somebody's name onto an account is that with the durable power of attorney, you're giving permission, you're not making that person an owner of your assets. So in my mind, it's a safer way of protecting you and your resources. If the person that you name in your power of attorney to be your financial decision maker happens to have a divorce going on or has some financial issues of their own, let's say they have a business and the business is not doing well, maybe they need to consider filing for bankruptcy, none of their personal financial situations is going to affect you because they're not an owner. But if you choose to name them as a joint owner on a bank account, let's say, and they're having a financial difficulty, then legally they are considered an owner of half your account, and your assets would need to be reported in either their divorce proceeding or their bankruptcy, which means there's risk to you. So that's why I feel more comfortable with clients having a durable power of attorney than thinking they're going to take a shortcut and putting somebody's name as a joint owner on a bank account. Now, as you go through the planning stage, you want to be thinking about who to name. And one of the questions I frequently receive is, well, Stephanie, the person I want to name doesn't live here. They live in another state. They're on the other side of the country. Does that mean I can't name them? And the answer is absolutely not. It's not an issue of geographically where somebody is located. It's a practical issue of, have you discussed this with them? And would they be willing, when the time comes, to take on the responsibility to assist you in handling your financial affairs? So you want to pick the people that are best suited for the responsibilities. And another question I sometimes get is, I have several children, Stephanie. Should I appoint my eldest child? And the answer again is no, not necessarily. You want to look at, if you're going to name your children, you want to look at their skill sets. You want to consider, how do they handle financial responsibility? Are they financially responsible themselves? That's how you match up the right person with these sets of financial responsibilities. And I do want you to take the time to think about naming an alternate agent in the power of attorney. And that's for the simple reason that we don't have a crystal ball we can look into and predict the future. So I can't tell you if the first person you name in your document might get sick themselves, or they'll still be healthy when the time comes. So we need to have that plan B, the backup plan. And that's why I want you to think about naming at least one alternate, if not two. And you can choose the order in which you would want to name those individuals. But please, before you come to me or you go to another elder law attorney, please have a conversation with the people that you are thinking of naming. You'll find that while it might be a little bit scary to have the conversation, you're going to end up knowing whether or not that person is willing to take on that role. And by having an open dialogue, you invite the feedback from that person to be honest with you. They may end up saying to you, you know what, I can take that on, thank you, I'm honored, or I'm not ready to take that on, but I would feel much more comfortable making medical decisions for you. So I do encourage everybody to have an open dialogue with the people that they are thinking of naming. So the goal here is that by having the durable power of attorney, number one, you are choosing who you're delegating the responsibility to. Number two, it means that when and if you become incapacitated, we do not need to go to court and file for a guardianship proceeding, which would mean a judge would decide who would be overseeing your financial affairs. And number three, we're not only maintaining your confidentiality of your life because this is not a public record, it's not filed in a court anywhere, but we're also helping you to limit legal expense as well because a guardianship can be very expensive. Now, the next legal tool that's important for you to have in your plan is called a designation of healthcare surrogate. So this addresses the healthcare, the medical side of our lives. Now, we kind of take for granted when we're healthy that we can call up the doctor, we can make an appointment, we can arrange for transportation to go see the doctor, we can call in a second doctor, get a second opinion. We might take for granted that if we don't like the care we're getting at the hospital, that we request to be transferred to a different hospital. But what would we do if something was impacting our ability to make those kinds of medical decisions? So the purpose of naming a healthcare surrogate is to do exactly that. They stand in our shoes and they become our medical advocate, our spokesperson. Again, this is on a temporary basis because if we're able to regain consciousness, if we're unconscious, or regain our ability to communicate, then our surrogate steps aside and we again are in charge of making our own medical decisions. Now, just like I suggested with the power of attorney, I'm going to suggest here that you name at least one, if not two, alternate individuals. And you can decide on the order you would like to name them. If you want to name two, I don't really recommend naming more than two people to work together as what we call co-surrogates. Please be sure you feel absolutely certain that they are good communicators and they are going to work well together. Again, please talk to these people before anything is put in writing and signed by you. Now, there are other types of medical advance directives. A surrogate document is considered a medical advance directive because it gives instruction as to who you would like to make those healthcare decisions. Another important type of medical advance directive is called a living will. And a living will comes into the picture when and if our doctor diagnoses us as having a terminal illness or being in a persistent vegetative state. It allows us to put in writing how we would like to be cared for at the end of life. So we can address decisions such as artificial nutrition and hydration, hospice, a do not resuscitate order if we stopped breathing or if our heartbeat stopped. We can also talk about whether we would want to be an organ donor, and we can specify what would we want donated and whether we would want it donated for purposes of transplantation, or if it couldn't be used for transplantation purposes, would we want it to be donated for medical research and study? We can also address in the living will what we would want done if we had a secondary condition, secondary to the terminal illness. And that is just a few examples of things that a living will can address. The living will really should be tailored to the needs and the beliefs and the morals of each individual. So some people are impacted by their religious beliefs, others may be impacted by life experiences. So it's important that the living will be tailored to each person as an individual. So those are the 3 tools that I recommend should be part of your incapacity plan. They work while we're alive. Now, the estate plan is meant to work after we have passed on, after we have left the earth. So there's nothing that really affects our ability while we're alive, except for the revocable trust, which I'm going to get to in just a minute. So an estate plan might include a last will and testament, which would allow you to decide who you're going to name as personal representative. When you die, that person's job is to go through the mail, identify the assets, identify if there are any creditors you owe money to or people that owe money to you, and then follow the instructions in the will which state who are the beneficiaries and what are they to receive. If you have a beneficiary that has special needs, may be born with a developmental disability, or could have been born healthy but developed a disability or an illness later on, we might very well want to create a special needs trust for their inheritance within your last will and testament. And the benefit of having a special needs trust is that if the beneficiary cannot properly handle the inheritance, it then creates a management system. It puts trusted individuals in charge as what we call a trustee. And if your beneficiary is receiving financially sensitive government benefits, such as Medicaid assistance, SSI, subsidized housing, or food stamps, we want to make sure that the inheritance does not result in them losing those benefits. So the way to accomplish that is to direct their inheritance right into the special needs trust. Some individuals choose to have a will as well as a revocable trust. Now they work together, they don't replace one another, but they actually work in harmony. And here's how the revocable trust works. First, it's intended to enable a person to pass on assets at death without those assets first having to go through the court process we call probate. They want to maintain privacy in their lives. So the revocable trust will, just like the will, designate who are the beneficiaries and what are they receiving. But in addition to that, while you're alive, you must take your existing assets, whatever they are, could be your home, bank accounts, could be life insurance, could be an annuity, and you need to either title the asset in the name of your revocable trust, that's how it avoids probate, or designate the revocable trust as a beneficiary, let's say of a life insurance policy, or beneficiary of an annuity. So again, the goal is for the asset to avoid probate. The other benefit of a revocable trust is that it can work while you're alive should you become incapacitated. And how it accomplishes the second goal is that while you would be named in the document as the trustee, you're also going to name a successor trustee, somebody that would step in should you become incapacitated. And so that person would have authority to administer any assets that are in the name of the trust. So it actually serves 2 purposes. Now, as part of any estate plan, whether you decide to have a will or a trust, it's important for you to confirm beneficiary designations. This means that when you opened an asset, let's say a bank account, you might have on the signature card named certain individuals to inherit that account when you die. Now, the reason it's important for you to check beneficiary designations if you have a diagnosis or your spouse or partner is diagnosed with an illness is you don't want to be shocked after the person has passed on to find out that you weren't the beneficiary designated or there was another beneficiary with you. So now is the time and the best time to check those beneficiary designations. If a beneficiary designation says one thing, but the will says something different, there is going to be an impasse. And should that occur, what wins out is the beneficiary designation that is on file with the financial institution. So even though the beneficiary designation may say John Smith, and the will says John Smith and Mary Smith are beneficiaries, the financial institution is legally obligated to follow the beneficiary designation that's on file. So I do encourage everybody, check your beneficiary designations now, because if it needs to be changed, it's important that the owner of the asset be mentally competent to make that change. And we've seen in situations where somebody is in an advanced stage of an illness, they may not be competent and they may not be able to follow through. Another tip I'd like to share with you is take the time now to review the ownership of assets. Don't assume that you understand that it's equal or maybe it's unequal. So this is something that the attorney will do with you when you go to an estate or a long-term care planning consult. A few other tips I want to share with you is it's important during this process to organize your legal as well as your financial documentation. Now, I recognize some people may find it easier to be organized than others, but taking the time now to organize is really going to save you time and stress down the road. This might mean that you decide to have a scanner and to not just have a paper file of documentation, but have a scanned set of documentation as a backup. I also suggest that people make a list of their professional contacts. Name, what do they do? Are they your financial advisor, your accountant, your attorney, etc.? Have all their contact information available. And it's always a good idea when receiving a diagnosis to schedule a planning meeting with all your advisors to be present, because it's important that what one professional advisor recommends is going to coordinate with what your other advisors are doing. You want to make sure that information is being shared. That way, your team of advisors can work best for you. It's also recommended that you make a list of your digital assets. And this is a relatively new term that's come about in the last few years as a result of technology and people doing more of their financial affairs through the internet. So I'll share with you a very quick story. I had a long-term client who had been a client of mine for 25 years pass away about the 4th month of COVID. And I was named as his trustee and his fiduciary in his documents. Unfortunately, he did not share with me his username and passwords. And even after going through the house and looking for places where he might have written them down, I was not able to find them, which made things much more challenging, and it took much longer to be able to take over things like bill paying and be able to get into his digital devices. So I highly and strongly recommend that people prepare a list. Identify, for example, what financial accounts you handle online. What are the usernames and passwords? Do you use two-factor authentication? Very important. At least let your fiduciaries know where you are keeping that list. It will make what they have to do more efficient and more effective for you. So now we're going to talk about how do you finance long-term care if you or a loved one find yourself being diagnosed. Well, the place I always like to start is, do you have long-term care insurance? This is a very important part of creating a long-term care plan. Why? Well, with long-term care insurance, like any insurance, you've been paying premiums that entitle you to have the insurance company pay for the type of care that you purchased. So you might have purchased a policy that is just home health care services, or perhaps your policy is broader, and not only does it include home health care, but it includes coverage if you go into assisted living or skilled nursing. If you haven't purchased it and you now have a diagnosis, you probably will not pass medical underwriting. But if you have a partner or a spouse, I would suggest that your spouse look into this for themselves. So the earlier you look into this, the lower the premiums are going to be, and the more opportunity you're going to have to get the coverage that you're looking for. If you don't have long-term care insurance, then we need to evaluate, what do you have in savings? And is there a retirement plan that could be accessed to cover costs that are not covered through Medicare or through private insurance you might have through employment? At this point, you're going to want to discuss this with your accountant, because you want to understand any tax impact that can result from taking distributions from a retirement plan, such as an IRA or a 401k plan. Now, if you or your loved one are a veteran and you served in the military, we would want to explore services that you could obtain through a program called Aid and Attendance. Now, aid and attendance has nothing to do with whether the veteran was injured during wartime. Its goal is to provide financial support to the veteran or the veteran's spouse so that they are safe and they have supportive services. To qualify for aid and attendance benefits, there are both financial requirements as well as service requirements that need to be met. So let's start with the service requirements. The veteran is required to have served 90 days of active duty, and 1 day must be during a declared period of war. Now, Congress has published on the VA website the beginning as well as ending dates of all declared periods of war. And if you know somebody that served in the Vietnam War, I do recommend that you go to the VA website, because there is some misunderstanding about what is the beginning as well as the ending date of that war. So best to go by what is published by the Veterans Administration. A veteran must also have an honorable discharge from their service. Now, if those requirements are met, then the VA is going to evaluate an application looking at the financial requirements. Now, regardless of marital status, so this applies to both single and married individuals, the limit on net worth currently for this year is $129,094. So if you are single, that is the maximum you can have of net worth. That does not include the value of your home. And that same limit applies if you're married. So that includes the assets, the resources of both spouses, even if assets may be titled in the name of the non-veteran spouse. The VA is also going to look at income of the veteran, and there is an annual income limit that is going to change each calendar year. So you want to check with the VA as it sets new limits every January 1st. So just because a veteran might have what is perceived to be a higher income level doesn't mean they're automatically excluded from aid and attendance, because what the Veterans Administration allows us to do is to reduce the income by any medical expenses the veteran incurs that are not reimbursable through insurance. So think about copays, think about out-of-pocket deductibles, think about any type of medical expenses that are not considered covered because they're not traditional and approved. Maybe you go for acupuncture, maybe you go for homeopathy. All of those can be applied to reduce the veteran's monthly income. Now, another veteran benefit that's available if a person needs a skilled level of care is that each state has VA-operated state nursing homes. Our closest nursing home here in Broward County is located in Pembroke Pines. If a veteran has a disability rating of 70% or greater, they will automatically be admitted. There is no waiting list for them. I've given you on the bottom of the slide the website for the Veterans Administration. It's www.va.gov, and there is a lot of helpful information there under the pension section for veterans. Now, if you're not a veteran or you're not married to a veteran, then we want to consider as part of a long-term care plan exploring eligibility for Medicaid assistance. Now, this is the other federal program that is meant to work for people with long-term care illnesses, people that might need care in the home if it can be safely provided, or care in an assisted living facility in the community, or a skilled nursing level of care. But just like with the VA, there are financial eligibility requirements in addition to medical requirements. So an individual applying must have no more than $2,000 of countable resources, and if the individual is married, their spouse is limited to having countable resources not exceeding $130,380. Now, for the person applying for Medicaid, there is an income limit, and they look at gross income, meaning before there's any deductions, let's say for withholding tax or for health insurance. That income limit in Florida is going to change every January 1st, and it is usually tied into what the federal poverty levels are. So if there's a, let's say, 3% increase in Social Security, we're likely to see that same increase in the Medicaid monthly income limit. For this year, that income limit is $2,382. Now, if somebody's sources of income, let's say it includes Social Security, retirement, as well as a pension, exceeds the gross limit, it does not mean that they're not eligible. It simply means that in order for them to qualify, Medicaid will want them to have a legal document called a Medicaid income trust and a separate bank account for that trust so that the income which exceeds the limit will be placed into that trust account every month and used for their medical expenses. If a person does that, then as long as they meet all the other eligibility requirements, they can be approved for Medicaid assistance. There is no income limit for the spouse that is not qualifying or applying for Medicaid. Now, you do need to be aware that Medicaid is going to look back 5 years to see if a person applying has given away assets and didn't receive equal value in return. However, federal law provides a great exception, and that is there is no penalty if you transfer assets between spouses, and that's because the law protects the marital relationship. So if, let's say, both spouses' names are on a joint asset, and next month one spouse is diagnosed with an illness, we can remove the ill spouse's name and there is no penalty. We can even do it 1 day before applying for Medicaid, and that is acceptable. If we do a transfer outside the marital relationship, however, that is not protected, and that is going to cause a delay in qualifying for Medicaid. Now, there are certain resources that Medicaid knows have a value, but Medicaid is willing not to count them. So when the financial review is done, these assets can be kept and the person can qualify. Probably the most important asset for any of us is our home. Now, federal law does impose a limit on the value, and Florida's limit is currently set at a value of $603,000. That's equity value. So if you have a mortgage, we would take the value of the home, subtract the mortgage to arrive at what is the true equity value. You can also use resources to make repairs and improvements on the home, and that is considered an acceptable use of assets to qualify for Medicaid. But please be very careful about thinking that you have to sell your home or you have to transfer your home to a family member, because doing that will actually cause the opposite result. You will take what is a non-countable resource and you will end up creating a transfer penalty, which will cause you to be denied, and you'll have to wait a period of time and then reapply for Medicaid. Now again, there are certain exceptions in the law. And one exception to transferring the home is if the home is transferred to an adult child who has been serving as a caregiver for a parent that's been ill. That is a very rare exception, and we have to evaluate the facts to make sure before you do that, that it's going to work. Another type of exempt resource is called income producing property. This simply means that you have rental property and you are making reasonable efforts to rent it out, whether it's on a seasonal basis, a vacation basis, or year round. So if you purchase income producing property, this is a way of legally qualifying for Medicaid assistance. Another exempt resource that is not counted is the automobile. And if you're married, each spouse can have an automobile in their name, and it is not counted. Florida is one of the few states that allows somebody who is applying for Medicaid to have a retirement plan, such as an IRA or a 401k. And Medicaid will not count the value of the retirement plan so long as the applicant is taking the minimum required distributions on a monthly basis. So if you arrange to take the minimum distribution monthly, not once a year, then that is a way that you protect your retirement plan. Certain annuities can also be protected, and it depends on the year that the annuity was purchased. If it was purchased after 2005, when the law changed, you will have to designate the state of Florida as the first beneficiary of anything remaining in your annuity at your passing, unless you have a spouse. The spouse can be named first, and then the state of Florida needs to be named second. Alternatively, if you don't have a spouse, you're not married, or your spouse has passed, or you're divorced, but if you have a child with a disability, another exception applies. You can name that child who has the disability as first beneficiary, and then name the state of Florida second. And last but not least, if you're going to arrange for funeral arrangements and you make that arrangement irrevocable, which means should you change your mind later on, the funeral home is not going to give you a refund in value, then funeral arrangements are also considered an exempt resource. Now, two other tools that can be very helpful if a person has resources over the asset limit and they need the help from Medicaid to pay for long-term care. One is called the Special Needs Trust, and this works for individuals under age 65. So again, timing is very important. There is no limit on the amount of money or the assets that can go into a special needs trust. And one advantage is that you can choose who is the trustee to handle it. You cannot be the trustee. So you may want your spouse, you may want your adult child, or a trusted friend to serve as trustee. Now, we all know that the government doesn't do things without expecting something in return. There's no such thing as a free lunch, we say. So what makes this work under the law, which has been law since 1993, is that when the trust beneficiary passes away, anything remaining in the trust must go to repay Medicaid for what it paid during that person's lifetime, whether it be payments made to a home health agency, to a nursing facility, to a doctor. If you use up, and I hope that you do, everything that's in the special needs trust so that you've had better quality of life and better quality of care, then there's nothing left to repay Medicaid. And if you're married, your spouse does not have a legal obligation to repay Medicaid. Now, what do we do if somebody is diagnosed and by the time they realize they need to do the planning, they're already over age 65? Well, our second option that's available is called a pool trust. So here we can use the pool trust for people who are under or over 65. Again, there's no limit to the amount of assets that can fund the special needs trust, but it must be cash. So it can't include, for example, real estate. It can't include investments. Here, one of the major differences is that with the special needs trust, you could choose the trustee. It could be an individual. But here, the law requires that the trustee be a charity. Now, in Florida, we have many pool trusts that are already set up, run by a variety of different charities with different charitable purposes. So if you're going to consider a pool trust, it's important for you to learn about what is that charity's intended purpose. Is that something that is aligned with your vision, with your goals. Here there's also a variation compared to the special needs trust, which is that at the trust beneficiary's passing, what's left in the trust can either go to Medicaid to satisfy Medicaid's lien, or it can be given to the charity to be used for the other people that are participating in the pool trust. So the way the pool trust works is that there is one trust where multiple people decide to join in. So if you imagine a pool of funds, those funds can get a better rate of interest because they're all being invested together rather than separately. And there is one trustee that is administering the trust for everybody. So these are great planning options, especially being available at the last minute if there was no long-term care planning done in advance. Another tool I want to quickly mention is called a personal service agreement. And this is ideal when we have a situation where a relative is helping to care for the person that's been diagnosed. And maybe they've even had to cut short their work hours, or they've had to stop working outside the house completely in order to be a caregiver. So Medicaid will honor a written legal arrangement between the person who's ill and the caregiver, as long as it's in writing. We also need the caregiver to be maintaining a log of the services they are providing, how often, how much time is expended. And what we like to do initially in order to be able to value what the services are worth is to have somebody keep a log for a few weeks. And then we evaluate the log and we use hourly rates that are lower than what a professional in the community would be paid. And what we're doing is we're extrapolating that value over the ill person's actuarial life expectancy. So examples would be personal care services being provided, managing the home, property management, for example, doing financial decision making, taking care of the finances. All of those types of services are compensable, and this is a way to legally reduce countable resources so somebody can qualify and get the additional financial assistance they need. So I do want to mention something for everybody to be aware of, and that is, you all know, if you're savvy consumers, that there's always ways that there can be advertising and marketing that is misleading or false. And it occurs here in the Medicaid area as well. So be careful of people that tell you that they are Medicaid experts, especially if they are not an attorney practicing in the area of elder law, or they're not board certified in the area of elder law. What we've seen over the last couple of years is a non-attorney convincing somebody to hire them. They might even say, I used to work for the Medicaid agency, I know what to do. You want to be very careful about getting advice from somebody that's not an attorney. You want to be careful that that person might prepare a legal document. Or they may say to you, yes, I work with an attorney, but you're always having to communicate and deal with the non-lawyer. You never get to meet with the attorney. You don't know if the advice you're getting is actually from the attorney. It's very important that you have a direct relationship with the attorney you're going to work with. Be very careful about somebody who's not an attorney making decisions on strategy, decisions that are going to affect whether or not your Medicaid application gets approved. So in closing, I want to make a few more suggestions, and that is putting aside what we talked about today, which is the legal aspect of planning and the financial aspect of planning. Having a strong support network for both the patient and the primary caregiver is so important. And that may include friends, family, clergy people that you depend upon, and also consider a support group or private therapy to help you get through it. There's also community resources that are available. Our Aging Disability Resource Center here in Broward County is a wonderful resource of information, and there's one located in every county of the state. There are also what we call focal points and adult day centers that can be very helpful for older individuals. And you might find it beneficial to work with an aging life care manager who is a social worker or a nurse by education and training to help you get through some of the non-legal issues. And there is a national organization of aging life care professionals that can help you if you're located in another state, or perhaps you have a relative or loved one somewhere other than Florida. So I hope that you found this webinar helpful and that you're leaving feeling relieved knowing that there are solutions to aging challenges, whether they're things that happen in the normal aging process or if you've received a diagnosis and you are going for treatment for that condition. I do encourage everybody that the most optimal time to plan ahead is when you're healthy and competent. You're going to have more legal options available to you. You'll avoid the expenses that can be associated with doing emergency planning. And we always want to look for the optimal plan that's going to allow you to preserve your privacy as well as your independence. If you already have a plan in place, please consider updating your plan when there are major life changes. That is when there's a marriage, a divorce, a birth, a death, or as we're talking about today, there's been a medical diagnosis. But most of all, this is something that you don't want to attempt to do it yourself. So I'm happy to take questions from our audience, and I hope that you will join me in the future for further educational webinars. You can go to our calendar on the website, www.fl-elderlaw.com, to register. And if you registered but something came up and you missed the webinar, go to our website to the webinar page and you'll be able to take advantage of seeing the recorded webinar. We also have on the website a free document checklist to help you organize your thoughts and get started with the planning process, as well as a gift certificate for a discount on either an estate planning consultation or a long-term care planning consultation. So I'd like to open it up to any questions now. Well, if there are no questions, I'd like to thank everybody who joined me today. Have a wonderful weekend. Stay healthy and stay safe.